harshest sanctions that the Board of Registration in Medicine has at its disposal. Why? Not because he recklessly endangered patient safety or intentionally committed some act that implicates his moral character or his fitness to practice medicine. No. His license to practice medicine, his constitutionally protected right to pursue the profession of his choice, was indefinitely suspended in a case where he was only found to have violated regulations that the board contends have no intent requirement whatsoever. The board's contention today is that these two regulations, 243 CMR 2.0711A and section 1.035A10, both have no intent requirement, not negligence, not intentional misconduct, nothing, and that they were constitutionally permitted to take away Dr. Welter's right to practice on that basis. I'm here today to ask this court to reverse that suspension, as it runs afoul of both the state and federal constitutions and is arbitrary and capricious. It cannot stand.
Do you have any cases to compare it to in terms of behavior that would have merited this discipline, or behavior that was worse that got less discipline?
Yes, there's a string cite of different cases in our brief that where the board has found worse behavior and has actually imposed a lesser sentence. Perhaps the most on-point case that I can point you to is a case where a doctor engaged an associate that was not licensed to practice medicine. He practiced for 2 years under this doctor, and then when the doctor went to renew his license, he failed to disclose 3 malpractice suits, including one based on the death of a patient where this unlicensed practitioner was involved. In that case, the doctor did not receive a suspension. He received a reprimand and a fine. And there are plenty, we've pointed this out at every stage of the game to the board.
Has this court ever, there's a tremendous amount of discretion as far as discipline goes. I can't find or I haven't seen a case where this court has said that they've overstepped their bounds.
Where the court has ever found that the board has overstepped its bounds? No. Well, this is the first time actually that this constitutional issue has been raised to the board.
No, I mean, I'm just looking purely at the remedy right now. We'll get to the constitutional in a moment. Just the remedy. It does seem harsh, but do they have a right to be harsh?
There is a case called Brockington where the court did find that the board abused its discretion. And yes, discretion...
In sanction?
I'm sorry?
In the sanction it imposed?
Yes. There, and the court, yes, the Board of Medicine does have discretion, of course. It's a regulatory authority and discretion is afforded. But in this case, I think it's extremely clear that the decision to sanction Dr. Welter in this way is both arbitrary and capricious and constitutionally problematic. When you're interfering with someone's right to pursue their profession, which is a constitutionally protected substantive due process right, there has to be a rational basis related to
So do you take into account that it was a probationary period, that he can continue to practice and run his business?
So there was a probation agreement, if that's what Your Honor is referring to, that he agreed to enter into after the suspension was initially imposed, of course, yes. However, there was a period of time where he was actually suspended, and that was it, and he had the option to pursue that. He had to aggressively pursue a probation agreement, which would allow him to continue to practice. However, if you look him up...
Counsel, can I ask you a question about that then? Given that he had this option, and so although it's termed an indefinite suspension and seems harsh and forever, in fact, it wasn't harsh and forever. So he can now, and as I understand it, is now a practicing physician. So I guess how does that fit into your constitutional argument, that, while termed an indefinite suspension, in fact, it wasn't. He's still able to be a doctor and earn his keep.
Well, I would disagree with the the characterization of it as not harsh and not permanent, because although he is able to practice, if you look him up on the Board of Registration of Medicine's website right now, it says he was suspended. If a payer wants to enter into an agreement with him so that he can be part of an insurance plan, they're going to look him up and they're going to see that, and that's going to impact his ability to engage in
Does
these.
it show the suspension is still active, or does it read as if it's over?
So what it specifically says is that there's a stay of suspension and probation. However, it says specifically under the word action, it says suspension, and anybody can look that up and see it right now. If you Google his name, an article comes up from the Board of Registration of Medicine about this decision, and the fact that they entered an indefinite suspension against him does not mention the probation agreement. And importantly, it's irrelevant to some extent in terms of the constitutional argument how bad the punishment was. Of course, we contend as a secondary argument that in this particular case, applying this particular sanction is constitutionally
But
problematic.
it's a rational basis test, correct?
Correct.
On the constitutional grounds?
Correct.
And there's not a rational basis for the board to police itself as far as false advertising?
The board can certainly regulate false advertising, but the problem here is that there's no intent requirement whatsoever on the part of Dr. Welter. I think that in order to actually impair his ability to practice medicine, the board has to have some rational basis to do that that's going to relate to the public welfare and public health. And especially in this situation where this is a doctor that's well respected, that did absolutely everything in his power to try to do the right thing here, took the website, changed the website, stopped having...
That's after he was caught.
Well, before the board issued its statement of allegations against him, and it was, and mitigating factors are something that the board routinely takes into account, and it's something that should be factored in deciding whether a decision that the board has made, a sanction that's been imposed, is arbitrary and capricious.
So the board standard is that you can't falsely advertise, and I get the mens rea part of it. And we could get into what it says, but isn't it up to the physician to police her own website and representations and make sure that the people under their supervision don't hand out business cards that say doctor when they're not a doctor?
Well, turning to that particular point, I think that calling himself doctor is a little bit overblown in this case by the board, who in its statement of allegations against Dr. Welter, no less than 30 times referred to this man as Dr. Tan. So if that alone is enough to cause a problem and implicate public...
But I'm sorry, if I'm a patient and someone hands me a business card that says Dr. Tan, I'm going to assume that Dr. Tan is licensed to practice medicine in Massachusetts as a consumer, right?
Right, that's certainly a reasonable interpretation.
Okay, so isn't that false advertising then, or deception?
Deception is a particular term that implies there is a level of intent. And when it's used in any other context, it has a requirement that the person who has deceived someone has done so intentionally or at least negligently. Of course, with deception, it's an intentional tort. So to just say this is false and anybody could look at it.
Deceive, it says capacity to deceive. It says practice medicine deceitfully, engaging in conduct that has the capacity to deceive or defraud.
Right. And that is the problem, Your Honor. If we read that the way that the board says it's to be read, where there is no intent requirement and it's just an objective standard, anybody looking at it could feel tricked and then you lose your license to practice medicine, that's a
It
constitutional.
has to be a reasonable interpretation, but you look at 93A and what we infuse into that meaning in that context. And the whole point is that this is a consumer protection regulation. It's not the intent of the doctor, it's the impact on the public. That's the whole point of the regulation.
Well, the point of the regulation is to protect the public health. And I think there's an important distinction to be made when we're talking about 93A. Certainly someone could sue, the AG could go after a doctor for false advertising and could get an injunction saying you're not allowed to advertise this way anymore. But under 93A, there's no,
If I walk into a sports medicine clinic because I sprained my ankle or have an ACL injury, and the literature says that my doctor is board certified, am I to assume the person is board certified as an ortho as opposed to family medicine?
well, if it doesn't say either way, I suppose it's a reasonable interpretation on the part of the consumer to take that away from it, that he was certified in this particular area. But I think with respect to that statement on Dr. Welter's website, the technical terms of the sentence were true. And importantly, this comes back again to the intent.
A doctor says, you'll know the text, but it says basically the doctor is board certified, period, and then it goes on. But when I go on his website, I'm going there for hair restoration. I'm not going there for family medicine.
Right, but critically, whether or not the consumer could come away with that interpretation, there's still no intent requirement here, and that's what the problem is. It's a problem to start impacting.
Chloe indicated it's the capacity to deceive is the issue. And doesn't that statement on the website have the capacity to deceive the person who's looking for a board certified person in hair restoration, not family medicine?
So it could be read that way, to have the capacity to deceive, but we're challenging the fact that just evaluating Dr. Welter's conduct on does it have the capacity to deceive is not enough in order to start interfering with his right to practice medicine. If you look...
So you say we should strike down these regulations as violative of due process?
Correct. The way that this is written right now, we believe that it's constitutionally problematic.
It's all right for a doctor to say, no matter what the intent is, if we want to protect the public and protect them from being deceived, it's okay. If you're not a surgeon, to say we have surgeons. It's okay to suggest you're board certified in a field that's not applicable. And it's okay to say doctors when there's only one doctor.
Well, it depends on what you mean by the term okay,
What
Your
I
Honor.
mean is that the public is not going to be deceived, not what is the content or the consciousness of the doctor who puts this false advertising up on the website, because we're not trying to protect the doctor, we're trying to protect the public.
Right. However, of course this can be regulated in some way. The government can say this should not be out there, and perhaps that 93A is the correct avenue to do that. It's a different question when we're dealing with the actual right to practice medicine, the doctor's license being taken away for something where the board did not find, and claims that it didn't have to find, that he acted with any level of intent whatsoever.
Keep on saying that. You said it in your brief, and you said it now twice in argument. I don't know where there's anywhere in the briefs where, in the record, that says that the board found that there wasn't an intent to defraud or deceive. There is a reference about an aspiration to build a larger business and hire other doctors. That's true. But where in the record does it say that he had no intent to deceive? Because I was looking through it as carefully as I could.
Well, it does say that he had no intent to deceive the board with respect to another issue in the decision. I think the overall tenor of the decision implies that he was trying to do the right thing the whole time. He asked the MMS multiple times whether he was allowed to use Dr. Tan in the way that he was, and he changed everything as soon as he realized it was a problem.
That's on Monday morning. That's after everything already happened. You keep on saying that they found there was no intent to deceive. What he did, I can't find that, number one. Number two, his whole point is, in his words, this is what sets us apart. This is what makes us special. This is what sets us apart. We got surgeons, we got doctors, we're board certified. Not only did they not say there wasn't an intent to deceive, it seems clear that there was.
Well, I think, actually, if you read the board's decision, or it's, the board specifically determined that it did not have to find intent on this
I
point.
understand, but it didn't find what you keep on saying, that he didn't intend to deceive.
Well, it didn't make a finding
I know.
that he did.
It's careless at best. Would you give us that?
You know, I disagree with the characterization that it's careless. I think he
Wow.
went out of his way to try and fix the problem as soon as he knew it was a problem. I think he went out of his way.
All right, indulge me. Assume it's careless. Doesn't, as a consumer protection matter, doesn't it put the burden on the physician to carefully go through their website and their practice to make sure that it's fair to consumers?
Yes, but the board would have had to proceed through a regulation that requires intent of some kind.
So
And
can I ask you a question about that? And coming back to the constitutionality of the ability to practice medicine and earn his keep, as I said earlier, so the constitutional test is rational basis, correct?
correct.
So why is it irrational, that is not rational, for the board to say, as a matter of protecting the public, we're not going to have an intent requirement. Instead, we're going to hold physicians to a higher standard in their advertising and say instead, if it's capable of deceit, it's just not, we're not going to countenance that. Why is that not rational?
Well, I think if you go back to the very beginning when this court first recognized that this is a constitutional right to practice your profession, even back in the Lawrence case when this was first brought up, the court specifically stated that it doesn't run afoul of the Constitution to take away a license if somebody's engaged in gross negligence or something worse. This court hasn't explicitly decided whether no level of intent is required, but I think that it makes sense that if we're going to be taking this extreme step of suspending somebody's license, there has to be more of a basis in the public health for that particular sanction, and I don't.
That may be your estimation, and it could be mine as well. But why is it irrational to have a different viewpoint and say, you know what, we're going to have a broader onus on physicians if they want to practice. They're going to have their advertisements not just not intentionally deceitful, but also broader, not capable of deceit.
Well, it's certainly.
I mean, I understand your viewpoint that intent would be nice, and maybe that would be rational too, but why is it irrational not to have the intent requirement?
Well, it's just that this is such a serious constitutional right, and I don't think that we should be interfering with it unless there is some kind of intent, and especially where there was no actual harm to anyone. No patients were injured or anything like that. It seems extreme and irrational to be taking away someone's license to practice just on that basis.
Can I follow up on questions that Justice Wendland and Justice Lowy, which is the sanction itself? I understand that the regulation may not require an intentional violation, but the sanction here is, as you say, harsher than normal. Because that's just what Justice Lowy was saying, which is they are finding some intentional misconduct here, and that affects the sanction they're imposing.
So the board specifically stated that it did not need to find intent.
Doesn't need to find intent to find a violation, but it has a lot of discretion in its sanction. And here the sanction may be this is not just a simple, kind of capacity to mislead, but there's enough misleading behavior here that they may be, increasing the sanction because it's not just careless, it's more than careless.
So in response to that, I would point the court to the other decisions of the board where behavior that was not nearly as benign as this received a lesser sanction.
I know you gave us a string cite, but and I neglected to write it down. There was a case you said we reversed. What was the name of the case you began with the B? Do you have that?
It was called Brockington.
Brockington?
Yes.
Thank you.
But even just looking at the board's own administrative decisions and how it's exercised its discretion in other cases that are somewhat similar, they've been much more lenient, and the decision to go with an indefinite suspension in this case is arbitrary and capricious. And unless the court has any further questions, for all of those reasons and the reasons in our brief, we ask that the court reverse the suspension.
Okay, thank you very much. Attorney Fergang.
Good morning, Your Honors. Samuel Fergang for the Board of Registration in Medicine. The question that was, or the issue that was reserved and reported to this court is whether the regulations which the doctors found to have violated should import into them the elements of the torts.
Before you get there, I want to end where counsel left off as far as the sanction goes in the Brockington case. We're certainly, personally, more familiar with the Board of Bar Overseer cases because there's more of them, and we see a lot more of them in the sanctions. We can compare apples to apples, not so much in this area. Can you address the Brockington case and other cases that show whether or not this sanction was disparate?
Your Honor, there are a number of reasons why the sanction was appropriate and well within the bounds of the board. First of all, it does reflect the more recent determinations of the board of dealing with this particular kind of misconduct. And I refer the court to the Burgess case, which in fact the plaintiffs cited in their brief with approval. Burgess, B-E-R-G-U-S.
And what was the sanction given in that case?
It was the same sanction as the one that was imposed in this case, an indefinite suspension with a probationary period in which the doctor would have to deal with this.
Doctor do in that case?
I think it was also a misreporting of credentialing issues. There's more detail in our brief, and I believe the case is actually attached.
And are
in
you
the
familiar
addendum.
with that Brockington case?
I'm not familiar with that, Your Honor.
Okay.
But I will say just in general, the specifics of this case and the context in which the sanction was imposed are well within the bounds of the board's discretion, in particular because what the doctor did here...
Counsel, one of the ways we measure whether or not a sanction is arbitrary and capricious is comparable conduct. And so you're saying the Burgess case is comparable conduct with comparable punishment?
Yes, Your Honor.
Okay, any others that we should be looking at?
No, Your Honor,
And if
but I
they're in your
think-
brief, I'm happy to just take them from your brief.
Oh, there are cases in the brief, but as a general...
Usually there are.
Thankfully. But in addition, I would also like to point out that if you look at the petitioner's brief, there is a significant time gap between the cases which they say were properly sanctioned and this case. And that time gap, I believe, is critical to understanding the board's actions, because during that time, the proliferation of web advertising expanded dramatically, and the board properly took into account the ramifications of the exposure to many, many more people of this kind of misconduct and what impact that would have on the reputation of the profession if it became widespread. So while you may have one sanction that was imposed for an isolated incident as recently as 2006, since then, the board has revisited the issue and imposed stronger sanctions for that very reason, because the impact here...
So what we need to do first, at least I need help with, is we have to evaluate the sanctions. So the first question is, what is the sanction? Is it an indefinite suspension, and we're comparing it to other indefinite suspension cases, or is it an indefinite suspension where the doctor is actually able to keep on practicing and run his business because it's a probationary period? What's the measure?
I believe the measure is the latter, Your Honor, because that is the more accurate description of the sanction that was imposed. It was a unitary sanction, a sanction that was an indefinite suspension that was stayed upon the execution of a probation agreement, which the doctor did. And the implication of that suspension and the impact upon the doctor are far, far different than a simple indefinite suspension, as admitted by the petitioner. He can practice today, and in a year, if he completes his requirements under the probation agreement, the suspension will be lifted, and he will be free to practice without any further oversight by the board.
Will
That
the,
is,
when he's looked up on the Board of Registration of Medicine as a physician, will it still say suspension or suspended? Or
my
will
understanding is
be
that it will show that he is free to practice medicine without any limitation. I'm not sure if it will show the prior imposition, but it will certainly show that he is now free to practice medicine without any limitation by the board. And that is a far different situation from being involved in an indefinite suspension. And I would also point out in terms of severity that at the beginning of this case, the petitioner executed a voluntary agreement not to practice medicine. So in terms of the impact upon the physician, he had already voluntarily ceased to practice medicine. So the only time lag in his ability to practice was that 1 month, I believe, that it took to review and execute the probationary agreement. And it's certainly well within the constitutional powers of the board to do so. As the court has adverted to, there's a rational relationship between the practice of medicine and the reputation of a physician to the public, and imposing a sanction to preserve the reputation of the profession, as was the case here.
As far as the regulations go, you use a legal term of fraud, right?
The word fraud appears nowhere.
Is this fraud?
There's
It
a
says
capacity to deceive or defraud.
Defraud, okay.
I'm being pedantic, Your Honor, I'm sorry.
All right. So, fraud usually requires some materiality, right?
Yes, Your Honor.
Here, there's no materiality requirement.
No, Your Honor.
Isn't that a problem?
No, Your Honor. Again, because linguistically we're talking about engaging in conduct, it has the capacity to defraud or deceive. And again, as my opponent adverted to, it would be reasonable for a person to look at someone calling themselves doctor and assume that they are licensed to practice medicine. So that shows that there is a capacity to defraud the public materially by people believing innocently that a person is qualified to practice medicine in Massachusetts when they are not. That is the intent of the statute.
I think but as it looks, just looking at at the regulation itself, apart from this case, absent the common law restrictions on defraud or deceive, doesn't it have due process concerns or problems where it could be for immaterial representations, could leave a doctor subject to discipline?
No, Your Honor. I think that here the misrepresentations were in fact material. The board may not have made a specific finding because it was not necessary to do so. And that is because under the language of the regulation, it's only whether there's a capacity to do so. And the evidence was clear that there were repeated references to Clark Tan as being one of the two doctors in the practice. That should, on its face, is a material misrepresentation. And in fact, as a matter of evidence in this case, the two complainants that were part of the record stated that they were in fact deceived by those representations. So there was evidence in this case of materiality, although I do not believe that is necessary. It's an objective test, and if you look at the Aspinall case, for example, there's no requirement for materiality under the standard of deceptiveness, which is what the doctor was found to have committed here. And the reason for that, of course, is because if we raise the standard, we run the risk of allowing representations of this nature to proliferate without sanction. And that's something that the board is very concerned about because of the ease with which that kind of misconduct can be spread through the Commonwealth. Just a keystroke, and you can have hundreds of thousands of people receiving these advertisements and being misled with drastic consequences because of the magnitude of what is going on. There are other provisions in the regulations that do require materiality, that do specifically invoke the language of fraud, but this is not one of those regulations, and that standard should not be applied to this case. It would defeat, if it was to do so, it would defeat the purpose of the rule, which is to protect the public.
You never changed the regulation to address internet publication, correct?
No, Your Honor. I don't believe there's any need to. The fact that the
Well,
language...
it goes to the harshness of the penalty, because what you've told us when we look at this is that it was treated less harshly when it was print, or however people would advertise back in the Stone Age. Now, with the advent of the internet or publication, we've increased the punishment. And I'm just wondering whether or not that's fair, given that it was a standard, and now you're basically saying because you can more widely publish, we're going to increase the penalties without notice to the physicians of the world.
Well, I believe it's fair, Your Honor, because the focus of the regulation is on the protection of the public and not the protection of the physician. And where in the past, what might have been considered a metaphorical slap on the wrist would not achieve the deterrent effect that this type of sanction did. Although at the same time, I would argue that this is not a severe sanction. What it does do is require the physician to engage in some course of learning and probation to prevent it from recurring.
Well, it was severe for a month.
Yes, Your Honor. Well, there you go. A month. If that is the standard, then we're in big trouble. If a month's suspension for misrepresentations that took place for 2.5 years about something that clearly was misleading to the public, I don't believe that's at all a severe sanction to be imposed. And in this case, what is interesting, and may have also led to the degree of sanction imposed, was that the petitioner did not concede that he erred in total. He did remove the advertisement content relating to Clark Tan, but he insisted throughout the hearing that he had done nothing wrong in describing himself as being board certified because of his claim that it was technically correct. So,
Can I ask a question about board certification? Are you board certified in hair restoration or just surgery and family practice?
Dr. Welter was board certified in family practice. I am not aware of a board certification that exists for hair restoration, or at least one that's recognized by the board in Massachusetts.
So his misrepresentation was to suggest he could do surgery? I'm confused by exactly the misrepresentation.
Right, so if he can't be board certified in hair restoration, how is there an issue?
By that very means. The public doesn't know that. You need to...
I certainly didn't know that.
And the doctor certainly did know that. And
I should, but...
I sympathize and empathize, Your Honor. But the issue here is that very issue. The word board certified has a certain impact upon the lay public, and in the context in which it was made, the implication to the lay public is that the petitioner was board certified in hair restoration when he was not, and he insisted that there was nothing wrong with what he did, and I think that merited a sanction of the nature that was imposed by the board.
When the board decided to up the sanctions in connection with the increased capacity for websites to reach many, many people, did it provide notice to physicians?
No, Your Honor, and I want to be careful. I don't want to suggest that the board now has a blanket rule that it will always impose a indefinite suspension with probation whenever there is a misrepresentation. Every case is different. the board looks at the conduct in every case and then imposes an appropriate sanction based on the misconduct in every case. So the fact that this was a web-based advertisement was a factor in the board's consideration. But I think the important issue for physicians in general is, and I would hope that it would be true, that physicians are not conducting themselves based upon the nature of the sanction that they may incur. I think they should be conducting themselves based on the assumption that they will not violate any of the regulations imposed by the board. So I don't think it's necessary for there to be specific notice to be given to physicians that they should not issue misleading advertising on the web. I think it's clear that they know that already, and that there's no differentiation in terms of what they should not do, whether it is in print or on the web or any other forum. And the nature of the sanction, again, it's a matter of it's a factor, but it is not an exclusive one. And unless the court has any more questions, I rest on my brief.